start sharing. Well, actually, I'm not going to start sharing my screen yet because we're going to do introductions first, just since you can see our faces right now. So we are going to be presenting on implementation of the new Title IX regulations in, this says, oh shoot, this says 10 days. It was 100 days. Oh my gosh, can you imagine if it was 10 days? So with that, I'll let Lauren introduce herself.
That might have been a Lauren edit on accident. Hi, my name is Lauren Hasselbacher. I am the Title IX coordinator at UW-Madison. I've been in my role about 3.5 years now, and prior to this did protected class discrimination, harassment, misconduct investigations at the University of Colorado Boulder.
And hi everyone, I'm Tonya Schmidt. I use she and hers pronouns. I work at the UW-Madison with Lauren very closely as a Title IX deputy. I also serve as the Assistant Dean and Director of the Office of Student Conduct and Community Standards, and we have a role to play with Title IX investigations that involve students. So Lauren and I spent a lot of time together this summer for those 100 days. So
virtual time.
A lot of virtual time. Yes. Good clarification there. So I'm going to start sharing my screen. And we've got a little PowerPoint here. I'm going to get it into presentation mode. Let me just see if folks slideshow, let's do slideshow. Okay. Does everybody see that?
Yep, looks good.
Okay, and where are my closed captions? Hold a second.
They're on, Tonya.
Oh, they were on. Okay, fantastic. I guess I just can't see them. So, so we thought it would be important to bring the new Title IX regs to the WCPA conference. Because it seems like it's taken a little bit of a back burner. I don't know if people have realized this, but there's some really serious changes to these new regulations. And people aren't talking about it because there are also other things that are sort of more pressing right now, but we thought it would be good for us to walk through these. So the few things that we're gonna do is we're gonna just talk to you about what the new Title IX regulations and rules actually say. We're going to talk about the process and what we went through, which was a pretty quick one, to do this within 100 days, which is what the Department of Education asked us to do. We are going to talk some specifics on how we are doing updates to our process at UW-Madison, and we actually have not had to use it yet, although we do now have a case that we may need to use it on. So we'll be able to share more at a different time with you about that. And then if we have time at the end, we will do any questions that we can cover. So in May, the Department of Education, Office of Civil Rights, published these new rules for Title IX compliance, and they gave us a deadline of August 14th. So if any of us had big plans for the summer, they were thwarted. These address some specific procedural requirements for disciplinary procedures and really swung the pendulum back, in my opinion, to really focus on the rights of the accused in this process. So what that meant for us, for those of you who don't know, we are a system of schools, and many of our fine system colleagues are on the call. This meant we had a lot of red tape to get through. So the Wisconsin Administrative Code covers all of those UW system schools, and there's a regent policy, and then all of our campuses have their own individual policies as well. All right. So we had to do this in a quick fashion. I'm going to turn this over to Lauren because I would say she was the most involved with all of these various other areas as far as implementation is concerned.
Yeah, thank you. So we were somewhat anticipating these rules, but it had been a long time coming. So if those of you paying attention, you might remember that the proposed rules were published in November of 2018. So we've been waiting for the final rules since then. So we had actually already organized a campus steering committee kind of sitting in wait until the final rules were published. And so that comprised of compliance staff like myself, human resources, student conduct with Tonya involved, our Clery director, and then other people from the Division of Student Affairs and Communications, knowing that our campus was going to be wanting updates on how we were going to respond to the rules. We I personally, along with a member of our Office of Legal Affairs, also was part of the UW System Work Group that was organized by our UW System Office of Compliance and System Title IX Administrator. And so there were other members from UW campuses, both student conduct people, Title IX people, and legal, to work on drafting what would become the emergency rules in our state code. And that's what's in place now, and the changes and adjustments that we'll be talking about, that's what's currently in the emergency rules that were modified as a result.
I just realized I skipped a slide, Lauren. I don't know if you noticed it as well.
That's okay.
But just some of the new Title IX rules, which I think a lot of us are familiar with, but this will be available to you on the WCPA website as well. But basically, some of the things that the new regulations do is narrow the scope of enforcement. So those of us who don't have codes of conduct that apply to off-campus, those institutions are very limited in the way that they can confront Title IX. We'll talk a little bit about how we dealt with this with our UWS Chapter 17. But it also narrowed the definition of sexual harassment. And if any of you saw the definition before these regs, it was still a pretty high standard to meet as well. So it narrowed it even more, I think, making it a little bit more difficult. And then one of the big areas is that the Title IX process now requires live hearings to do fact finding in, and we'll talk about some of the nuances of that. One of those is that all institutions now have to appoint an advisor in order to do the cross-examination for both parties, if those parties don't have their own advisors, because the parties cannot do that on their own anymore. And then also just really limiting the type of information and statements that come into those live hearings. So if a witness decides that they don't want to participate in the hearing, or if a complainant, which this has happened a lot in our process prior to this, if a complainant doesn't want to participate in the hearing process, basically any information that they have provided as far as a statement or any sort of supporting evidence or information cannot be used in that live hearing.
Is it back to me? Sorry, I have numbers in front of me. Okay,
kick it back
sorry
to you.
about that. So, so as we sat down with these rules and tried to figure out how it was going to work with our current state code for students and employees, I would say there was a pretty quick consensus, both on our campus but across UW system, that there wasn't much of an interest in similarly narrowing our policies. Just expectations from our campus community, we knew that it would not be a popular choice to limit our scope, limit our jurisdiction, make higher standards for finding people responsible for misconduct violations. So we kind of got past that hurdle right away. And so from there went to figure out how we can still, appropriately respond to these issues in a way that meets our campus expectations to the extent possible. So in doing that, we adopted the necessary version of sexual harassment that we're required to have, but we also included a version that looks much more similar to the previous version. So, which is a slightly broader, slightly easier standard to meet. So we can charge under either definition. We also added a sexual exploitation charge, which I'll get into in a little bit more detail in a few slides, to cover any other conduct that we thought might be missed by these new definitions. For employees, we really only adopted these rules as far as necessary. And so for both students and employees, we created what we're calling Title IX misconduct. So we have our general, broader sexual misconduct definitions and policy violations. And then there's a subset of that we're calling Title IX misconduct, which triggers the new requirements of the federal rules. So in comparison to the employees, for students, we tried to make them as similar as possible. We wanted to be clear and understandable for people who are coming and who are involved either as a complainant or respondent. So we tried to make them as consistent as possible, but there's a couple carve-outs and caveats for those cases that require, or that include Title IX misconduct specifically. What we're trying to be really clear to campus about in all of our communications and trainings and presentations is that there has not been any change in the support resources that we can offer people who have experienced some type of sexual misconduct. So our geographic and context jurisdiction hasn't changed. We're still assisting people if the misconduct happened off campus or outside university programs and or activities. Same goes for our confidential resources. As long as you're a student or employee, you have access to those same resources, and we'll always refer you to the appropriate community resources as well. Same protective measures, same supportive measures. There was a lot of alarming headlines that came out when these rules were published, and we know our students and employees were reading those. So we're really just trying to emphasize that despite kind of maybe what they assumed or learned or read about the general federal Title IX regulations, our campus is remaining committed to responding to a much broader scope. Similarly, for responsible employees, so that's the term for people who have mandatory reporting obligations of sexual misconduct to the Title IX coordinator, we kept all of those designations the same. The rule does probably allow for fewer people to be in that designated role, but as a campus, we have not made any changes. So that's something else that we're trying to make clear to people, that even if the Title IX rules and regulations allow for us to have a smaller population of mandatory reporters, we have not chosen to do so. Okay, so kind of back to what we were talking about with those definitions. The ones that the federal government are requiring are based in federal criminal statutes. So that's for stalking, dating, domestic violence, sexual assault, and we adopted those as required. Previously, our state code used Wisconsin criminal statute definitions, so that is a switch for us. I don't think there were any major red flags for the change for stalking, dating, domestic violence, and sexual assault. That a little bit remains to be seen how this plays out, but we did adopt those without much change. Where we did feel like we needed to do something different than the rules was that broader definition of sexual harassment that I mentioned earlier. So the federal rule requires, in order to meet a sexual harassment standard, that the conduct alleged has to be severe and pervasive and sufficiently offensive to effectively deny someone access to their education or workplace activity or environment. So we have that as one charging option. The other option says that the alleged misconduct must be sufficiently severe or pervasive and sufficiently offensive, and that it has to simply interfere with that person's education or workplace versus effectively deny access to. So it's a little bit easier standard to meet. It more closely resembles the Title VII language, which is the civil rights statute for workplace discrimination. And so we thought it was appropriate to include both, because as a university, we really have an obligation to respond to both of those standards.
And Lauren, can you just clarify for the group where we maintain these? Is it in the actual policy and also the code, or how is that actualized?
Yeah, good question. Yes, that's actually in the code for employees and for students. And for those of you who are familiar with the language of the emergency rules, if you're in UW system, we even made a slight modification for the proposed permanent rules that's even a little bit broader. So to expand the quid pro quo definition in addition to the hostile environment standard, because before the language basically indicated that the complainant had to be affiliated with our campus. Whereas we know there's situations in which, you know, a faculty member may be using their position at UW-Madison to sexually harass or put a student of a different university in a quid pro quo scenario. And we wanted to make sure we could still address that and hold that faculty member accountable if appropriate. The other piece that we did, which was something we've been Tonya and I have been talking about and wanting to do before, was to add this charge of sexual exploitation. A lot of other schools have this. For those of you not in the UW system, you maybe had something like this, but it was really meant to capture a lot of the types of complaints and conduct that we were seeing come in that we didn't have a clear definition for. So the actual description is simply when an individual attempts, takes, or threatens to take non-consensual sexual advantage of someone. The the definition of the policy has quite a long list of examples, but it's really meant to address these situations where people are taking photos or videos of someone without their permission, either naked or during sexual activity, distributing that without their permission, even if it was initially taken with permission, blackmailing people for the same. It also includes attempted drugging. It includes deception regarding contraceptives or condoms, and a couple other situations that weren't clearly an assault, weren't necessarily sexual harassment, but logically we felt fell under the sexual misconduct umbrella. And so we wanted to make that part of our policy as well. And that's also state code, so that's statewide for UW system. Okay, so this is kind of getting back to that subset of category we were talking about with Title IX misconduct. So while we've maintained this broader jurisdiction, broader definitions for our policy, there is the subset of conduct that we do need to apply those Title IX federal rules to. So that is conduct that meets those specific definitions from the government. The alleged misconduct has to have occurred within the United States. It has to have occurred within the university education program or activity, which is specifically defined as university geography or situations in which we had substantial control over both the respondent and the context in which it occurred. So you can imagine conferences, research travel, things like that likely wouldn't be covered anymore. The complainant must be participating in or attempting to participate in the education program or activity at the time they file a complaint. So again, that excludes any non-affiliated complainants or people who've dropped out or no longer interested in being at our campus. And then finally, they have to file that formal complaint or the Title IX coordinator has to do so. So as I'm sure for all of you who have substantial students who aren't residential, who live off campus, you can see how this does not incorporate quite a large portion of the complaints that we've been historically responding to and addressing. And so again, this is why we chose not to similarly limit our policy, but rather address this type of conduct the way we need to and are required to do so, but then also continue to respond to a broader scope of misconduct on our campus.
And just think about this in regards to COVID and how fewer students we have on our campuses right now. I don't know if that's the same throughout the state, but we have a lot less students living in our residence halls. So the likelihood of something happening on our campus that falls under Title IX is a lot less likely than it was in the past. Now, hopefully we won't be in this situation forever, but for now, I think this makes it even more difficult when we are serving most of our students in a remote environment.
Yeah, that's a really good point.
All right, so we thought we would go through a couple slides that sort of talk about how we are going to actualize this or logistically deal with this on our campuses. And we understand that not everybody here is falling under UW system and has to follow those procedures, but these are just some ideas that maybe will be helpful to you to adapt on your campuses as well. So we are going to continue to utilize Chapter 17, and whether or not the case actually involves Title IX misconduct, it only changes one procedural aspect of the hearing. So we actually, in UW system, have done live hearings. Many other universities across the country had not engaged in those, so we were a little further along than some other campuses that really had to make some sweeping changes to their procedures. We've always had the option of a live hearing. It wasn't something that we had to do, which under Title IX regs, we now have to do it. But one of the major things is that we cannot do any decisions before that actual hearing. So we have also, as Lauren mentioned, utilized our sexual misconduct cases. We have both Title IX regulations and our Title IX cases that fall under that, but then we also have the sexual misconduct cases, and we're utilizing some of the same techniques in both of those types of hearings. But we have, like Lauren said, a little bit more leeway to be able to do some of those other things like sexual exploitation under the sexual misconduct cases. Did you want to add any more to that, Lauren?
No, sorry, go ahead.
Okay. Awesome. Okay. So cross-examination. We talked about this a little bit earlier. This is an area, again, that we have offered in our live hearings at UW-Madison and other UW campuses. But what I mentioned that could make this a little bit more difficult is that if a party or a witness does not want to participate in the hearing or be subject to cross-examination, then that hearing panel or examiner cannot rely on any of their statements or information that they provided during the investigative process in order to make their decisions. And then also, we have to make sure that the panel or the examiner does not draw any inferences or, assume that somebody is responsible or not responsible only based on the fact that they are not at the hearing and do not want to provide information in that setting. What we know is that these hearings are very traumatic, especially for complainants in these situations. We also know that witnesses are very reluctant to show up at these hearings because oftentimes they're all in the same friend group, and so they don't want to put themselves in that situation. We do not have subpoena power like the court system does in our UWS Chapter 17. And so a lot of times we have witnesses that do not want to participate in a hearing. And as I mentioned before, many of our complainants have gotten to this point in the process and do not want to participate or put themselves in that traumatic situation. And they don't want to participate in the hearing. So those are some challenges that we have.
Sorry, I was just going to expand a little bit on the statement piece. So just to be clear, when they're saying that you can't submit their statement, that's, at least this is what the guidance, the 2,000-page supplementary material that we got with the rules, says that statement includes text messages, emails, statements to police, statements to a forensic nurse examiner. It could be statements made in a video. It says if they're not there to be cross-examined at the hearing, we can't use any of that in making a determination of responsibility. And so I say that really just to explain why this is one of the, as Tonya's going to get to, this is one of the rules that we really only applied when absolutely required to do so, because that just felt like a real hindrance to our investigative abilities.
And I'm not sure if we go into this in any depth on the rest of our slides, Lauren, but this makes me think about some of the other options that we have to work with parties to resolve the situation. I do think we have a few more options for informal resolution. Would you be willing to talk a little bit about that, Lauren?
Yeah, that's a good point, because we just limited for time. That wasn't a big focus of this, but we as our campus, we've always tried to use what we called informal resolutions or alternative resolutions when we could and when that was requested of the complainant. As you may know, previously under the Obama administration, there was really a prohibition against using like mediation or restorative justice programs to resolve sexual misconduct. The Trump administration has lifted that ban and said, yes, you can go ahead and use that when appropriate. And I think our campus is going to look into some of those more formal options. We just don't have a strong structure for that yet. But what we have incorporated into the code and into our policy is coming to basically like settlement agreements. So there was a version of that in 17 before. What it does allow for now is to come to some sort of settlement after a notice of investigation has been issued. It does require the consent of the complainant in these formal cases for us to stop doing the formal investigation and come to a settlement. If a formal investigation was never initiated, if it didn't meet the Title IX requirements, we're still free to do those kind of other educational conversations, preventative measures as we see fit. But we do have, in some ways, a little bit more leeway to resolve even more serious cases that otherwise would have required an investigation with other sort of resolutions if the university and the two parties can come to agreements on those.
And that might actually become a more popular way, or chosen way, I should say, of resolving the case, just knowing the restrictions on the hearing and having to be subject to cross-examination. Otherwise, I mean, really, if a complainant does not want to participate in the hearing, we're probably going to see a not responsible finding there, which is probably not what that complainant wants. And it's a bit of a catch-22 for them. So I do think that this might be an option that more complainants choose, just to avoid that trauma and at least trying to weigh in and get some sort of closure and conclusion that they're somewhat agreeable to. If you remember in the past for settlements, if you're a conduct officer here, we were able under Chapter 17 to do a settlement with our respondents, or the people who are accused of the misconduct. And we only had to confer, was the word that was used, with the complainant. In this situation, the complainant actually has to agree to the terms of the settlement. It's a little bit of a tweak there. Okay, so at least how we did it at Madison, and I get that we are resourced at a different level than some other campuses, and we are grateful for that. And I wish everybody had the same process that we had, or the same amount of staff to help with this, because as you know, these cases are the most difficult to investigate and adjudicate. So we've been very blessed to have an Office of Compliance, which includes Lauren's office that she leads. I think we're changing the name to something soon, instead of Title IX office, since it will be going to do sexual misconduct as well. We haven't quite, that wasn't as easy a process as we thought it might be in the first place.
Never is.
It isn't, but we will try to do that. But what we previously did is Lauren has two investigators, and then she's also done investigations in the past as well, is they would go ahead and investigate the case and do all the fact finding, and they would write up an investigative report. That investigative report, of course, was shared with the parties. They gave feedback on it, and then a final report was sent to the Office of Student Conduct and Community Standards. What we would do then is I would gather two other people in the office, so that we always had 3 sets of eyes on the investigative report, and we would read through an investigative report and decide if there was preponderance of the evidence, is it more likely or not, that the respondent committed any of the Title IX violations or Code of Conduct violations. At that point, we would then write a finding letter for sort of our recommended findings. So we would say, we think this person is responsible for these codes, and give our rationale as to why, and then we would send that off to the parties. From there, so that was like an initial finding of responsibility. From there, depending on if it was a suspension or expulsion, we would automatically have to go to a hearing unless we entered into one of those settlement agreements. Our office would then take that process forward with just one of the people who did the conferring on the case, going to present that at the hearing if the hearing was the next step. Well, now we can't do that because, as I mentioned before, we are not supposed to do any initial findings of responsibility before that live hearing, because again, the new regs really emphasize that all of the information, it needs to be cross-examined if it's going to be put into the hearing. And so now what we have decided to do at UW-Madison is have the investigators from the Title IX program do some factual findings and policy analysis of that final investigative report that they have written. And then if there is no settlement that they can do with those parties prior to having to go to a live hearing, then we will set up the live hearing. And unlike before, where we would make some findings and present at the hearing, now the Title IX program investigators will be presenting their facts and their investigative report at the hearing. Questions about that before I move on? Okay. Because I do, one of the pieces of the regs is that the person who investigates has to be different from the person who makes the decision, who decides if the student is responsible or not. Is there anything, is that correct, Lauren?
Yeah. And I think one of the reasons too that we felt like we could switch over is that, previously hearings were only happening when there was a initial finding of responsibility. So the student conduct employee who made the decision was kind of, for lack of a better word, acting as kind of like a prosecutor. But to the extent that they're explaining their decision, explaining why they felt, some sort of discipline was appropriate for that particular case. Now we're going in from a much more neutral perspective, because there's also potentially going to be hearings when the initial recommendation was not responsible. It's solely, an initial finding at this point. So when the investigators are coming in, they're really going to have to come in from this neutral standpoint of, this is what I did, here's who I talked to, here's the evidence I collected, time for the hearing panel to make the decision.
Yeah, good clarification. And we realize this will tax our smaller universities throughout Wisconsin and the nation, because they may not have another person to do that. So there's going to need to be some, decisions about who's going to do that. And some people are talking about looking at outside investigators and paying them a lot of money to do these investigations. Whereas in the past, say Danny at UW-Whitewater could do the investigation, could do the findings, could take it to the hearing. Now that's, it's not as simple as that. So definitely a big change and a heavy lift for a lot of our smaller organizations. So just a couple logistics that are new, that are different for UW system. We used to put a hearing packet out 5 days in advance. Now that got doubled to 10 days in advance. And for anyone who knows how much work that is to gather all that information and get it out in a timely manner, that will be a bit of a lift. And then, this is just, this came from one of our trainings for Title IX for our committees. But they will receive any of that technical training, and we actually purchased or bought into the SUNY system platform that has a lot of great training resources. So anybody who makes decisions on Title IX cases has to have annual training, and so we are in really good shape to be able to provide that at a really high level now, thanks to UW system. And then we have implemented more of a pre-meeting. So we would meet, like maybe half hour, 15 minutes before a hearing, the committee would meet. But now we're going to do a pre-meeting just because there's a lot more things that go into the hearing and a lot more responsibilities for the actual chair of the hearing when the actual hearing takes place. And then at the hearing, what we have decided for our campus is that an Office of Student Conduct staff will be the chair of the hearing, which is a little different. We're kind of just moving sort of the expertise of the folks in the Office of Student Conduct into that chair role. We do have to go through the process of being appointed by our academic staff assembly because we are a shared governance campus. And so it'll be, say, myself or my colleague Nick or Ryan will be the chair of the hearing because of some of those extra responsibilities that we will have during that time, and our knowledge base and just some of our previous training. But then we will also be joined by a student and then another faculty or staff person. We have gotten a little bit of pushback on that, just saying, oh, this is going to sway, the vote. But as you know, it has to be unanimous, or not unanimous, but, what is that? What is the word I'm looking for?
Majority, two-thirds majority.
Majority, two-thirds majority, thank you. That we believe that it will be a discussion, and there, one person can't make the decision for the entire hearing. So we have worked with that with our Associated Students of Madison, at least one of our representatives, and also did get a little bit of pushback from our academic staff assembly But when we told them that there would be 2 other people and that it was really kind of just moving the point, and then also the fact that there are appeal processes after this. There are several, probably many more than there should be at this point, to let that student challenge that decision. The other thing is that there's a lot of things that chairperson has to do. They have to determine relevancy of questions, which can be really difficult to do right in the moment, especially when questions are kind of being done rapid fire. Because as you know, a lot of times parties choose attorneys to serve in these roles to do the cross-examination. So we will be able to make those decisions, again, just with like a higher knowledge. It'll take a little bit of pressure off of our committee members who, you know, may only do a case once every 3 or 4 months.
We are approaching close to 5-minute mark, and there were 2 questions from a previous slide, so we can revisit those when we get a chance. So
okay, perfect. I think this is the last slide, actually. I'm sure there's many more details that we could answer for you in the Q&A section, but just for the finding, it does have to be preponderance of the evidence. Some people say this is 51% or 50% in a feather. Anything that would persuade a reasonable person that it is more likely true than not that the misconduct occurred. Another change is that the burden is on the university to prove that the respondent is responsible or not, and we have to assume that respondent is not responsible until we determine that the evidence or the information meets that preponderance of the evidence standard. I think we even have to say that right out of the gate in the charge letter or the notice of investigation, that the respondent is not responsible until we prove that they are. Before it was sometimes it was seen as like the complainant's job or other information being provided to the hearing to prove that point, but it's actually just saying that the burden is on the university. And then the other great joy that myself and my staff get to do as the chair is that we will write the first draft of the written finding, which we were writing a finding beforehand, just at a different point in the process. And this will be, again, helpful to our committee members who don't serve every day. This is not their main role that they play in their jobs. And it'll just help them have a little bit more meaty finding to look at and review and finalize to get out to the parties. 111-916-326. Okay, I know we went through that very, very quickly, but looks like we have about 6 minutes left. Those are our emails. I will also put them into the chat, but I'm gonna stop sharing my screen right now just so I can see folks' faces and we can answer some questions.
Now we had a question from Ryan back on one of the slides and asking about 2 of the different definitions, if you need kind of both of them, and if it covers international programs. I can't remember what the name of that slide was, but it was before the slide that was called Now.
I believe it was Title IX requirements.
Yeah, there we go.
Yeah, so it's kind of, yes, it's all of those requirements. So basically what OCR is saying is that we are only going to respond and oversee these types of issues that occur on campus. And so it has to meet all of those requirements. They're really limiting their scope of enforcement and response. And so, yes, you're correct. That would mean that all of our study abroad programs don't count because they're outside the United States. And, field research, if it's not, your campus owned, if people are going on, other foreign conferences, things like that, none of that's going to be covered by OCR. They're not paying attention to that anymore. What they've said is universities are free to address that type of conduct how they want outside these rules. And so within UW's system, we've mostly said we're going to pretty much continue addressing that the same way that we always did. We're just, now it's not under this Title IX misconduct umbrella. And so the phrase we chose for Our scope of enforcement is university supported or sponsored activities, because we wanted to come up with like a phrase that didn't sound the same as the phrase OCR defined. Does that answer your question?
Yep, thank you so much.
I think another area that we sort of glossed over is we talked about cross-examination, but we now as an institution need to give those parties someone to do that cross-examination. And for Title IX cases, and I'm not sure where we landed with our sexual misconduct cases, but for Title IX cases, we have a pool of attorneys from all different types of backgrounds. I think they're both defense attorneys and many other types of attorneys. They will be paid by the university to support whatever party does not have somebody to do that cross-examination. So I think that'll be a new interesting process that we embark on.
Yeah, that's a pretty big change. You're right, one we didn't give a lot of or any focus to, so thanks for bringing that up.
This is the first time Lauren and I are doing this together, so we'll learn a lot for the next group. So thank you for being our first group.
I did see, I posted the OCR definition for education program or activity into the chat in response to someone's question. So you can see it's a long definition, but somehow still ends up with a pretty narrow scope. So in addition to like normal clery geography, it is situations in which the a registered student org owns the property. So for some of you that may cover your fraternity and sorority houses. And then it's that other situation in which the organization has substantial control over the respondent and the context of the misconduct.
Do other smaller universities want to weigh in at all on some of the ways that they're putting into practice the new Title IX regs? Not to put you all on the spot, but we're just presenting from a larger campus that has a few more resources. I see Ryan has another really good question about sort of how are we supporting students after cross-examination, just because of how traumatic that can be. Lauren has a fantastic staff member in her office that she could tell you about.
Yeah, I mean, we were able to hire a case manager in February, so he got to be with us for about 2 whole months before we were all sent home, not even. And he's really tasked with all the initial outreach for complainants and then respondents too, if they end up needing accommodations, which is another part of the new rules. But and just to clarify too, we will appoint an advisor if someone doesn't have someone to conduct cross-examination on their behalf, but they are still welcome to bring their own advisor to do that, to hire their own attorney, to have a victim advocate do that if that's within the scope of their role. And of course, we will always be referring people back to their confidential support services before and after these hearings. We try to be as clear as possible about kind of what all of our individual roles are. Like, investigators, even the case manager, we're still within the compliance office. We want to be compassionate and considerate, but in the end, we're compliance staff. And so we try to be clear with people about that, but then also make sure that they are aware of the confidential support resources and community resources that might be more appropriate for those types of support after a compliance hearing.
Yeah, at Whitewater, we're still working on the finding advisors for the respondents. That's been a little more tricky. But for complainants, we work really well with a local organization that they will do training with us on what our hearings look like and things like that. So that way we have that separate organization that will come in right from the beginning and work with them and work with the complainants. Because again, we're not a large office, even though I'm the investigator, but because of these new rules, we now have to have somebody else who makes the actual findings and somebody else who will present on behalf of the university. And we just don't have that many people. So we've really had to look for the outside organizations. And I think our biggest struggle is trying to find those those advisors for the respondent if they don't have their own. Although we have found most of them, especially for the more serious cases, will bring in their own lawyer. So
Yeah.
You could ask your chancellor for some money. You could, I'm sure, hire some attorneys because they want to get involved in this process, because not a lot of attorneys get to be involved in sexual assault cases or other Title IX cases. They just don't go to, the court systems very much. So we had a very large pool of attorneys who wanted to help out in this situation and be paid, of course.
Danny, which school are you with?
UW-Whitewater.
Okay. So yeah, I know UW's system is working on also gathering an attorney advisor pool. It's still being paid out at an hourly rate, but hopefully, you'll get notifications about that as well.
Other questions as we end our time? I know that was a whirlwind. Please take our email addresses if you have any questions. We don't have all the answers, but we have had 100+ days of working really specifically in this area if you want to even just chat about it.
Okay, thanks, everybody.
Great, yay. All right, remember to fill out the program evaluation I dropped in the chat there, and thank you all for attending.
All right, take care, everyone.